All right, let's go ahead and get started. We are here today with Jennifer Pinkham. She's one of the partners at Pfeiffer Pinkham LLC, and she's here to talk about employment laws in Massachusetts and things to be on the lookout for.
Thanks, Meg. Good morning, good afternoon, everyone, and welcome. Thank you for joining us today. Thank you to Meg for having me. I'm excited to present today. There are so many topics and so much to talk about, so I'm excited to dive in. Meg said that your group is very interactive, so I'm excited about getting questions throughout the presentation. So to the extent you want to interrupt at any time and have questions and share, it sounds like this group really gets a lot out of sharing with one another as far as best practices and what issues you're facing. So feel free to jump in at any time. I'm going to go ahead and share my screen with everyone here. Can everyone see my screen okay?
Yep.
Great. So as I mentioned at the outset, there were so many topics to pick from, and Meg mentioned that you wanted to talk a little bit about what are the hot topics upcoming in 2023. And there are a lot to be on the lookout for. So I just want to say that this is going to be jam-packed. It was hard to kind of cut and narrow the topics because there's so much to talk about, but 2023, there are some things to be on the lookout for. There's some things that happened in 2022 that I want to make sure all of you are aware of. So we are going to dive right into the topics. Some of the changes and topics we're going to talk about today are remote work in the post-pandemic world. I'm assuming that because many of you are running architectural firms, many of the architects or other individuals may be remote still, or they may be hybrid. So we're going to talk a little bit about what you should be thinking about there. The other hot topics we're going to talk about are pay equity, non-compete updates, FLSA updates, separation issues, so separation from employment. There's a recent decision from the NLRB that impacts everyone that I want to make you aware of, and then a case from 2022 relative to the Massachusetts Wage Act that I want to make sure is on everyone's top of mind as you separate people from employment. And then of course PFML, because we know that that's been something that all of you I'm sure have had to deal with people going out on leaves, and what to think about in 2023 when it comes to PFML. So first topic, we're just going to talk about remote work in the post-pandemic world. If you are still having individuals work remotely, make sure that you have a good policy in place. Who's eligible for remote work? Is it by employer choice for the business? If so, how is that approved? How is it outlined? Make sure that it's specified. And then thinking about, and we're going to talk a little bit about this when it comes to PFML as well, but is remote work and a reasonable accommodation under the law? So can someone say to you, I have a medical condition, so therefore can I work remotely? Those are things you need to be thinking about as you're entertaining remote work and as you're dealing with requests for working remotely. What are your expectations as far as working remotely? What are the hours? What's reachability? You know, how often should people be connected? What are the professional standards? If someone's on Zoom, the dress code. Most of your people are professionals. So for the most part, I think you are going to have people that are presenting in a professional light, but sometimes you might get someone that doesn't. And so you really need to have those standards outlined in your remote work policies. And then your workplace requirements, technology, making sure people understand that there's privacy concerns, that there's security concerns. And then how will you pay your remote workers? Make sure that your non-exempt employees, if there are any that are non-exempt, and we'll talk a little bit about exempt versus non-exempt in a couple of minutes, make sure that they're recording their time. Any questions about remote work up until this point? Are a lot of you still having people work remotely?
Yes.
So I definitely think that given that, I figured that given you are all professional service providers and a lot of the architects are probably still doing remote work or hybrid work. So it's something that you really want to have buttoned up as we enter into this post-pandemic world. Thinking about having a written information security plan, making sure that a WISP is required under Massachusetts law, making sure you have that. Thinking about expense reimbursement, emergency weather policies when it comes to remote work. Today, perfect example, right? We have this dud of a snowstorm, but are people expected to be on and working remotely? I would presume they are, but making sure that's clear and specified in your policy is important. And having a disclaimer about workers' compensation and injuries that happen at their home and the implications of having a home office. And a disclaimer about the continued ability to work from home, that the status can be readdressed, that you can change someone's status and require them to come into the office if it's not working out. Also, it's come up quite a bit recently with some of the companies that we represent where people want to relocate out of state. Make sure that you have something in your remote work policy that says to the extent they are relocating, they need to put you on notice and you need to provide approval that they can still perform their job duties remotely. Because some of your architects may need to go to job sites, they may need to visit with clients. So it may not be a situation where they can relocate to Arizona or Florida. So thinking about that and making sure that your policy addresses it so that someone doesn't say, oh, by the way, I relocated. And then you're kind of dealing with it after the relocation occurs versus having that in your policy saying, the extent you're relocating, you need to seek approval and make sure that the company is aware of such. And then again, is remote work a reasonable accommodation under the law? There's been a lot talked about under the ADA. Is it a reasonable accommodation? And the answer is not yes or no. It depends, as with many legal answers. And I know most of you don't like that when your lawyers tell you that, but it's just the fact is it's very fact intensive. And you need to look at each situation individually to determine if remote work is a reasonable accommodation. Because there are certain jobs where they cannot perform the job remotely. And even with architects, they need to be able to go on site. They need to be able to attend group meetings and do all of those things with other professionals. And so if they were to say, I need to work 100% remotely and I can never attend any meetings, that may be something that you cannot accommodate because their job is such that they need to engage with other design professionals or they need to engage with the client and they need to attend meetings. So every situation is unique and it would depend on what they had been doing before, what their job description is and the like. So just thinking about that going forward, we're going to see many more cases come out about remote work and whether or not it is a reasonable accommodation. And it is a fact intensive analysis, but thinking about it up front will be helpful to all of you. Does anyone have any questions up until this point about remote work and what to think about? We've got a quiet group so far. Meg, you said
I have a question.
Go ahead.
One of the issues we had, we have an office in California, an office in Ohio, and an office in Boston. And we have been telling people that unless they're willing to work in one of those offices, we won't hire you in another state. But we have had requests from people saying, I'd like to spend the winter in X place. And that's also proving problematic, but more so than just logistically, the tax implications are very complicated. And I wonder, can you say to somebody, it's a lot of work to set up a person out of state for several months. Like that's just one of the reasons we don't want to do it. But I don't know whether that's not.
That's a great question. And in fact, I had attended a webinar that other lawyers put on this very point. And they specifically stated that it's not discrimination to say we don't hire candidates from a certain state or that live in a certain state, or we won't allow people to work from a certain state. There's nothing discriminatory about that. So just making sure that you're treating everybody similarly and that to the extent somebody makes that request, it's denied across the board. And then you're going to be fine. I think that you're absolutely right. The tax consequences, so then you have to go through the analysis. Do you have to set up and register to do business in that state?
Yeah.
Do you have to withhold payroll taxes in that state? Is there any sort of paid family and medical leave or any other, like California, as you know, because you have an office there, there's many laws that you have
Yeah.
to comply with when you have employees there. So then you have to go through all of those processes when you're having an employee that's working in one of those states. And it may just be too cumbersome for smaller firms and even sometimes larger firms to do that. So you can make a policy that says, look, we're only having employees that reside in these 3 states.
Yeah.
For many reasons, including the administrative nature of onboarding someone in another state. So yes, you are within your right to do that.
Thank you.
Is there a threshold for the amount of time somebody spends in a different location that you would need to set up the taxes, or does that change from state to state as well?
Well, if they are what we call domiciled in that state, then obviously they would be a resident there. And so that's the situation now.
Right.
Domicile is looked at differently from many different tax organizations. So the DOR has a particular threshold that it looks at to determine if someone's domiciled in Massachusetts. But basically, do they spend most of the year in that location? And do they treat that location as their primary residence? Those are some of the questions. I mean, obviously, snowbirding in Florida or in Arizona or in someplace warm is not necessarily domiciling there. So those are some of the threshold questions. And if you want to be flexible, and there may be certain individuals that have been with the firm for 30 years that provide a real value, and you may want to accommodate someone working 10 months out of the year and they take 2 months off in the winter to spend in Florida, and maybe they provide some remote work while they're down there. I don't know. And that's, each of you running your firms has to make that determination. But just spending 2 months there is different than relocating. Hopefully that answers those questions. Any other questions about remote work?
Just a quick question about accommodations. Like accommodations for medical reasons, I understand, like someone has hip surgery and they need to work from home during a certain specific time and they ask for a very narrow, it's like 6 weeks or something like that. But accommodation for like people who have small children or other, like, is it just the rule like you set it, whatever you set it for one person, it has to be equal for everybody in the firm, right? Like you can't let a mom stay home because she has small children and not let a dad. Is that right? And is that accommodation or is that something else?
Yeah, I mean, I think it's accommodation. It's not the reasonable accommodation that I'm speaking to. The reasonable accommodation that I'm speaking to is under the ADA, the Americans with Disabilities Act. So it would be for medical related purposes. And so those types of accommodations, if somebody comes to you and says, I had hip surgery, I need to work remotely, it's 6 weeks, that's a reasonable accommodation, especially if they had been allowed to work remotely during COVID, right? Now, if they come to you and say, I need to permanently work remotely, I can never come back into the office because of a mental condition that I'm suffering from, it's debilitating, I have anxiety that prevents me from being able to come to the office. Those are different concerns, different questions that you would need to then go through that fact pattern. Can they do their job 100% remotely? Can we make this accommodation? If they can't perform the essential functions of their job remotely, then you don't have to provide the accommodation, but you have to engage in the interactive dialogue process with them. You have to go back and say, well, if you believe that you can't accommodate, you have to say, we can't do that, but maybe we could do this. You have to engage in that interactive dialogue process under the ADA. Your point, Anne, if somebody comes to you and has a non-medical related accommodation, I would like to have flexibility in my schedule because I get my kids off the bus at 3 o'clock every day. If you're going to allow those types of accommodations, I would make sure you're doing it for anybody that asks and kind of be consistent, because you don't want someone to come back and say, they're treating me different because of my gender. They're treating me different because of my age. They're treating me different because of my national origin. You want to make sure that you're treating everybody similarly. So I think that's a good question. And it probably comes up quite a bit. So diving into the next hot topic, which is pay equity. So President Biden is advancing a pay equity agenda, and in 2022, he made an announcement that the federal workforce course, was going to start regulating whether you could ask for salary history. And he also issued an executive order early on in 2022 that applied only to federal contractors, subcontractors, considering these new proposed rules regarding pay equity for job applicants and employees of federal contractors. So what we do know is this is top of mind federally. And we know that this is going to be a hot topic moving forward. And we want to kind of stay on top of it because we know it's going to be changing. There could be further regulations. When he made the announcement, he indicated that there would be further regulations coming down the pipe as far as pay equity. All that being said, Massachusetts already has pay equity. So I just want to remind everybody what the pay equity requirements here in Massachusetts already are. Those went into effect in 2018. And there was a basic prohibition against discrimination in pay that began in 2018. And basically it says that no employer can pay another employee differently based on their gender. And it goes into what comparable work is, when you can pay people differently. Massachusetts has had and continues to have some of the strongest equal pay laws, and women still earn 81 cents for every dollar men make. So just being aware of that and making sure that you're taking an internal tally of who's making what, doing those internal audits are key. Making sure you're paying people fairly and equitably is very important. And making sure at the hiring process, you are not allowed to ask what someone previously earned. You are only allowed to ask what they want to earn in the upcoming position that they're being hired for. It's a common mistake that people make. So make sure that you are trained and that you are training others that are meeting with people, that they are not allowed to ask, what did you make in your prior job? Because again, that's completely not allowed under the 2018 pay equity law here in Massachusetts. Permissible reasons for pay differences. So when we talk about pay equity, it doesn't mean that every man and woman has to be paid the same for the same job. You can pay people differently. What can you base that on? Seniority, merit, production, geographic location, education, training, experience, whether they have to travel for the job. So there's a lot of things that go into looking at what people make and why people make that amount. And so there are reasons to have variations in pay. These are the reasons that the law allows. So making sure you're doing those internal audits of your pay and looking at the men and women in your firms to determine, are they being treated fairly and equitably? And if they are being paid differently, can I substantiate why? Any questions on pay equity, which is going to be a hot topic in 2023? Okay, great. So the next topic is non-compete laws. Now, I don't know whether or not any of the firms have professionals execute non-competes, but I just want to bring this to everyone's attention. The FTC has invoked a new power to propose a ban on non-competes federally. So just be aware that this proposal would ban almost all non-competes in employment relationships, and the rule would require employers to rescind existing non-competes to the extent they have any. So it would nullify existing contracts, and the only place it wouldn't apply is in the franchisor relationships or in the sale of a business. So to the extent one of your principals sold his interests in the firm, he could be required to not compete, right? He couldn't go out and open another architectural firm down the street. So in the sale of a business, that would still be permissible. Currently, this is in a comment period through March 20, 2023. So we anticipate that sometime this year, something's going to happen with it. Whether it goes through or not, we're not sure, but we just want to make sure everybody kind of has their eye on it. I don't know how much it applies to all of you, but I wanted to certainly point it out because it is a hot topic in 2023. Just so that you're aware, Massachusetts does allow non-competes, but they did put forward the Massachusetts Non-Competition Agreement Act in 2018. And that act states that non-competes can be no longer than 1 year. They have to have a limited geographic radius. They have to have reasonable limitation on restricted activity, and they have to have garden leave, which is very important. They have to have at least 50% of the employee's highest annualized base salary has to be paid during the restrictive period. So for instance, if somebody made $100,000, they have to be able to make $50,000 during the restricted period. You pay them while they're being restricted from competing. So that's very important. A lot of people don't really understand that that garden leave is required. And it has to be something where the agreement is in writing. It has to be provided the earlier of the written offer or 10 days before commencement of employment. Reason being, obviously, the legislature believes that people should get advance notice of these obligations and be able to consider them before they accept a job. The agreement also has to expressly state that they have the right to consult counsel. So make sure if you are having non-compete agreements entered into that it complies with this 2018 law. If you have agreements from before 2018, they do remain in effect, even if they don't comply with these strict requirements. The law grandfathered in prior agreements. So you don't have to change the prior agreements. They are grandfathered in. Obviously, they would be looked at under the standards that were utilized before 2018, which still had the reasonableness standards of geographic limitation, length of time, and all of that that the courts looked at to determine whether or not to apply a non-compete agreement. Does anyone have any questions about non-competes and whether or not they're enforceable, or what's happening with the current climate right now is clearly going to restricting them or eliminating them? Okay, great. So I'm going to hop on to the next topic. So some other items to kind of be aware of coming up in 2023. These are items federally that are proposed rule changes. The overtime rules, white collar exemptions, they are slated to be updated in May. You may recall there were changes proposed under President Obama to increase the salary threshold. If you recall, it was $23,000 a year. It was very, very low. And there was a federal injunction to stop that from happening. And then the Trump administration did not proceed with the changes that were previously promulgated. So right now there's a likely increase to that threshold, that salary threshold. So it's a good time right now to take a look at your employee classification. Obviously, as design professionals, most of your employees are likely exempt from overtime. And so it's very common that they've gone through what we call a prolonged course of learning, and they're using their degrees to do their job. And so they're likely exempt from overtime, but there are likely other people at the firm that are not professionals that are not exempt. So just making sure you're looking at employee classification. How are you classifying people? Are they exempt? Are they not exempt? This is a big issue where we see employees get hit with audits and lawsuits. So just beware of this. Make sure that you're properly classifying your employees and follow along with these rules that are going to change in 2023. Any questions on that?
Yeah, I have a question about classifying non-design professionals as exempt. At what point would you consider, say, an administrative professional an exempt rather than a non-exempt employee?
So most of you are aware that there are 3 primary exemptions under the law. There's the executive exemption, the professional exemption, and the administrative exemption. Most of your design professionals fall under the professional exemption because they went through that prolonged course of learning. Executive exemption means someone manages 2 or more full-time employees and has the ability or their decision-making is given weight as far as hiring and firing of employees. So those are executive employees. The one that is the most gray is the administrative exemption. And that is really where most of the litigation occurs because it's more vague, and it states that it's someone who has the ability to bind the organization and the ability to make decisions with independent discretion and judgment with respect to matters of significance. So I know that's a mouthful, but basically what it means is someone that really can act without somebody else's approval. So I think that those individuals are few and far between. You know, you might have a CFO level type position that maybe they don't manage anyone else, maybe they're not a design professional, but they have the ability to bind the organization. They have the ability to enter into contracts, and they're you know, in that role, they are an administrative exempt employee. I think oftentimes people look at administrative exemption and think that means administrative assistant or administrative roles. That's not what it means. You really need to look at the job duties that the person does to determine if they meet the criteria listed in the administrative exemption. And that is ability to make decisions with respect to matters of significance with limited oversight, very limited oversight. So most people don't really meet that definition. It's very few. And so be careful about classifying people as administratively exempt.
What are the salary numbers known? Are they likely to change?
They are likely to change. There's a lot of comment period is going on right now. It's likely going to be in the 40 to 50, probably upwards between $40,000 and $60,000 range annualized salary. So that's probably what we're looking at as far as the changes are concerned. I think that it's going to increase, and they're talking about how much and what makes sense right now for the current climate and the current economy.
Okay, thank you.
As far as the employee or independent contractor classification, this is also something that's being proposed federally. The proposed rule makes it more difficult to classify workers as independent contractors federally. Again, remember, Massachusetts already has a very rigid 3-prong independent contractor test. So the individual has to be free from your control, perform work outside the usual course of the business, and the worker is engaged in an independently established trade or business. So remember, most people do not qualify as independent contractors, and most people are in fact your employees. And in Massachusetts, a worker is presumed to be your employee unless you can prove otherwise, and they have to meet all 3 of these prongs in order for you to be able to prove that. So while there is some federal changes that are happening, it's not going to have a lot of impact here in Massachusetts because we already have such a rigid independent contractor test, but I did want to make everybody aware of it. You may see in 2023 that there's changes coming for that. Any questions on the independent contractor law? So separation issues, I want to bring a couple of things to everyone's attention. The first is a recent NLRB decision, which some of you may have seen from last week or the week before. It's very recent. And what this the NLRB is the National Labor Relations Board, and the NLRA is the National Labor Relations Act. And typically you think of that as applying to union organizations, but in fact, it does apply to non-union organizations as well. And what this recent decision stated is that you cannot have non-disparagement language or confidentiality language in a separation or severance agreement. Now, typically when we draft severance agreements, we make sure that there's mutual non-disparagement language, and we make sure that there's confidentiality language saying that the employee is not allowed to disclose the terms of the severance with anyone else, unless it's their family member or their accountant or their lawyer, right? So we usually have strict confidentiality language. Well, the NLRB recently decided that we can no longer have those terms in a severance agreement. And if we did, that the severance agreement would not be valid. So basically, the NLRA specifically states that employees can engage in what they call concerted activity, meaning talking about wage issues, talking about workplace conditions. And the argument is that if you restrain employees from talking about this, then you're impacting their rights to engage in that concerted activity, whether they're unionized or not unionized. And so restricting them means they can't talk about their workplace conditions, or they can't talk about their wage conditions or what they received. So we need to be careful going forward. If you do enter into severance agreements or separation agreements, make sure that you're kind of on the lookout for this. If you draft them yourselves or you use a model that your lawyer has provided you in the past, make sure it's updated and up to date, because there needs to be changes made going forward.
And make the non-disparagement, you said you often use mutual, but I just had a question about this. Someone wrote and said, can you add language to the severance saying that nobody at the firm will disparage me? And our lawyer said, no, we can't control that.
Yes, and oftentimes we will say, you know, certain people, you know, maybe their manager or, you know, because again, you can't control what everybody does and what everybody says. It's very difficult. But you also, there are certain people that are under the firm's control that, you know, you can talk to the partners and the partners will not disparage the person or whatever it might be. So you can take certain steps. You cannot make a representation that no one will disparage this person, because you don't control all of your employees and what they say or do. And you don't want to get into notifying each and every employee as to this person's leaving. You can't disparage them, because then it from a morale perspective, it's strange. It looks bad. You don't want to go down that hole. But there are sometimes limited representations that you can make that you wouldn't disparage, or the partners wouldn't, or their immediate supervisor, or certain people that you know are in the know. But yes, I agree, your lawyer gave the correct advice on that one. So again, these are going to have to be changed going forward. So I think it's even going to have to come out where we can't have a representation that they don't disparage. Now, there are certain things that the NLRA says that employees can't do. And so what we're going to do as lawyers is make sure we tailor these. We won't call them non-disparagement anymore, but there are certain things that the NLRA says employees can't do. So we'll make sure that we walk that fine line as far as they can't defame or, you know, say things that are untrue and such. So we'll make sure that we amend our severance agreements, but it's something to be thinking about going forward. The other item I want to make sure everybody is aware of is that there was a case in Massachusetts 2022 relative to the Wage Act. And most of you all know that you have to pay employees in full on their date of termination. The day they're terminated, they need to be paid in full. There was a case in 2022 that held strict liability. And basically it held that this particular company paid the employee on the date of termination, but didn't pay out vacation on the day of termination. They just paid the final wages because they were calculating it, couldn't get to it. Weeks after discharge, they sent the check. Before any demand, before any lawsuit was brought, they sent the check. That being said, the employee still brought a lawsuit, proceeded all the way to trial, and won. And now there's a case that says that there's strict liability. If you pay a day late, it doesn't matter. You have to pay triple damages and legal fees. In this particular case, the lawyer had $75,000 worth of legal fees. So for this small issue, which was 3 weeks, you know, just the vacation payout, it ended up costing the company an exorbitant amount of money. So just be aware that as far as payment for a termination, make sure all monies owed, including vacation, is paid on that date. And if you have to delay the separation because you're getting your ducks in a row, then that's what you need to do, because you need to make sure that paycheck is issued the day the person is terminated.
Is that terminated for any reason if they voluntarily leave?
No.
Does that rule still apply, or is it just if the firm terminates them?
Yes, it's just if the firm terminates them. Any sort of voluntary separation, you can pay the person the next pay period. So if they quit, you can pay them on the next regularly scheduled pay period. But if you terminate them, you need to pay them in full on that day. So that's a good question. Any questions about any of that?
I have a quick follow-up question about vacation time. It's kind of in the same vein. If you change your vacation policy in reference to how much you can accrue, are you also like responsible to pay out vacation if you're changing like your rollover policy from like 80 hours to 40 hours and someone has 80 hours and you're like, oh, if you don't use it by the end of the year, like you're going to lose that time. Do you have to pay that time out as well? Or, with notice, are you okay without paying out the time and vacation?
So what you described, I would say, is likely legal. And that is because you provided a time within which someone can use it or lose it. That's likely legal. You can always make prospective changes to your vacation, and you can reduce the amount of accruals or the bank that someone has. But what you can't do is take somebody's earned benefits away. So for instance, if they have that 80 hours, you can't say, we're just eliminating the 80 hours. You now only have 40. You have to give them time to be able to use that 80 hours. And then you're going to tell them, for future reference, the bank is only going to go up to 40 hours. So just know you can always make prospective changes, but I wouldn't take anything accrued away from someone without allowing them time to use that.
Okay,
Does that
thanks.
answer your question?
It does. I mean, I think even if balances are like so unwieldy that there'd be no way that the person could take all the time off before, like, for example, the end of the year, unless they like took 3 months.
Yeah, and I think then sometimes you have to be careful what you wish for, because somebody might be like, oh, I have 300 hours, I'm using them,
Right,
So
right.
you-
Tell me
you
about
have
it.
to-
Tell me about
Yeah,
it.
but yeah, I think that you can certainly make those changes. I mean, I wouldn't say you should say, well, we're going to make the change in 30 days. You have 30 days to use it. It has
Yeah,
to be reasonable. And I think if it's a year out, that's something that's reasonable because people can plan and try to take their time. But I wouldn't implement something where it would be, they wouldn't be able to use the time in that time period.
Understood. Thank you.
So we
Any
had
other
somebody,
questions?
I have a quick one. We had somebody who had an excessive amount of vacation time. We were putting into, when we did our manual over, we were putting in new guidelines, and that person elected to switch it into sick time because sick time doesn't get paid out when you leave, and the firm owner said that was fine. I'm assuming they didn't break any rules because everyone was cool with it, and it was done with lots of lead time.
Yeah, I mean, I think you have to be careful with vacation because vacation is considered wages. And obviously sick time is not. Sick time doesn't get paid out upon separation. So it's a different animal. So you always have to be careful on what you're doing with vacation. I think where the employee elected to transition the time to sick time, it's likely not going to become an issue. But the company couldn't say to the employee, we're taking this and we're just going to make it sick time. Because again, vacation is considered wages under the law. So you have to treat it as such.
Thanks.
Any other questions on any of that? So PFML, obviously a hot topic. I know many of you have dealt with since it went into effect and are continuing to deal with it. I just wanted to give a few brief updates on the most recent changes to PFML and open it up for questions or discussion on if you've had any interesting PFML issues come up. So contribution rates were reduced to 0.63 of employees' wages. It was 0.68. So for all the lawyers, we're all kind of surprised that it's gone this way, and we all kind of predicted it would increase, and it hasn't. So that's good. It's good news for employers. And for smaller companies with less than 25 employees, it's also decreased to 0.318 of eligible wages. So this is a good thing for companies. The cost has gone down. It's a good thing for employees. The cost has gone down. I don't know how many of you are with private carriers versus with the Commonwealth. I don't know what you're seeing with private carriers, but obviously some people have changed and gone back to the Commonwealth that were with private carriers because the Commonwealth was less expensive. So people are kind of price shopping and deciding how to handle it. The weekly benefit amount, as many of you know, has increased as of January 1st, 2023. The maximum benefit amount is now $1,129.80. One of the things that people are talking a lot about is topping off and whether or not you can pay on top of PFML. Just know that if you are with the Commonwealth, you cannot top off. You cannot pay the extra money to the employee to make them whole. With a private carrier, you can. So some people prefer to be with a private carrier so that you can make employees whole. Obviously, the reason behind this is a public policy reason, that being that the Commonwealth doesn't want people to be out on lengthy leave. And if you pay them and make them whole, they may take more time off. And so it doesn't want to incentivize people to stay out on lengthy leaves. And so therefore it doesn't allow employers to top off. So that's something to consider going forward. Another issue is reimbursement through the Commonwealth. Some companies aren't aware that they can pay wages for the entire leave, and then they can seek reimbursement for the PFML benefit that their employee would have received if they so choose. So that's a different way of attacking it. Basically, they can decide, we have a paid leave policy, we pay 100%, but we're going to seek reimbursement from the Commonwealth. I don't know if anybody has done that, but it is allowed under the law, and it's an interesting variation, and some companies like that. The employee still does have to file for the claim, and it does still have to go through a very similar claims process. But instead of paying the employee, the Commonwealth pays the employer. It reimburses the employer. So that's something for employers to consider. And then obviously beware of retaliation. We all know that PFML came with heavy duty retaliation provisions, which are unlike any other, as far as the 6-month presumption of retaliation that exists in the law. So we want to make sure that when people return from leave or after they filed for leave, that they really are protected, and that the company isn't taking any adverse employment action against the individual unless they really have a legitimate business reason and can prove that there's a reason behind what they're doing. So beware, make sure that you are not retaliating when people come back. This is something I get consulted on regularly, where people have someone returning from leave, someone that's out on leave, they want to let them go, they don't want to bring them back, or they brought them back, they're not working out. And we really have to tread carefully because the law has that presumption. And even before PFML, obviously anyone taking a leave of absence was entitled to certain protections. So we had to be careful, but just beware of that retaliation piece and make sure to handle leaves and the return from work carefully. Any questions on PFML?
I have a quick one. I know that there's, I think this hasn't changed, but there's a 1-week lag between the time that it starts and that employees are allowed to use their vacation time to get paid for that week. Is that still accurate?
Yes, there's a 7-day waiting period, which usually would be 5 work days. And the employee can elect to use PTO, vacation, whatever time they have, be paid for that time period if they so choose. You cannot, though, and I want to just make sure everybody's aware, force the employee to use their time. It has to be at their election.
I have a question. I didn't know about the top off rule, and that's really interesting. It's something, we have a private carrier, and I have wished that we, could do that. What I remember when we when this all started was that we had a parental leave policy, and that we could not change our policy. We couldn't make it less rich. Like we couldn't, if we paid 2 weeks of parental leave, we couldn't suddenly stop doing that, which I totally understand. But right now, what I'm wondering is, could we take the time that we pay as a parental leave and top off? And because what's happening now is we have basically we have a policy where we're paying the employee to take leave, and we're also paying the private carrier, and they're benefiting from our policy, you know, for the weeks that we pay, and I'm just curious if you have seen how that sort of tension has been resolved.
Yes, I think a lot of companies have revised their own leave policies after PFML came to be, and some of them changed their leave policies, and because they might have had a 2-week parental leave, they may now do top off for 4 weeks.
Right.
Because again, it's actually mutually beneficial because the employee ends up being made whole for a longer period of time, and you're not paying for a benefit that you're ultimately not receiving, which doesn't seem to make a lot of sense. When you're paying 100% of somebody's salary during those 2 weeks, the carrier won't pay them because they won't
That's
allow
right.
the person to double dip. And
That's right.
so revising your policy, oftentimes people did it when PFML came out, but you can certainly do it at any time. And as long as you're not kind of making, like you said, making someone less,
less
but you're not
have less
you-
benefits. Yeah.
they're not.
And
And in
yeah.
fact, you could add to their benefit really by
Yeah.
allowing for top off for a longer period, because ultimately financially it would be the same hit to the company anyway, and
Yeah.
it would be a better result for the employee.
That's great. That's a perfect answer. Thank you. Really helpful.
Any other questions on PFML?
But wait, if you're with the Commonwealth, you can't do that because you can't top off.
Correct.
So it's only with private carriers.
That's right. That's right. That's why the reimbursement option is something that professional service firms are more likely to want to pay people because they're professionals, right? They you know, every company that I represent is very different and unique. But with professional service firms, sometimes they do want a professional to be paid 100% of their pay for a certain time period or for their entire leave. And so that's a different way of going about it, where you pay 100%, that's your paid leave program. And then you seek reimbursement from the Commonwealth. And you can do that just for parts of paid family medical leave. So for instance, you could do it just for parental leave, the 12 weeks of parental leave that you would offer full pay and seek reimbursement. Or you could do it for just medical leave and not for parental leave. As long as you do it across the board consistently and the policy is clear, then it's not discriminatory. But it's something to consider as to how you're handling your PFML.
If
And
the
what-
company is going to do the reimbursement route, does the employee have to fill out their paperwork differently? Is there some other step they would have to take?
Not really, other than they have to tell the Commonwealth they're going to be paid by the employer.
Okay.
Because obviously it asks, are you being paid by the employer while you're out on this leave or whatever? You know, there's a checkbox for the employee, because if they're getting paid by the employer, they're not getting paid by the Commonwealth. The Commonwealth won't allow both payments. So really the application is substantially similar.
Okay.
Any other questions on PFML? Or anything up to this point? So I think that, you know, I've certainly gone over a lot of topics in 2023. I'm not sure if anyone else has any that they see on the horizon, but I'm happy to open it up to the group. And we can certainly share any other topics that you think might be hot topics for 2023.
I had a question about the pay equity issue, which because we have a California office and their law is currently much stricter than Massachusetts, but we were told to expect that it will hit Massachusetts soon. And we don't have a lot of employees, but my understanding is that if any of our current employees or prospective employees ask what the salary range is for that, I'm sort of asking how granular we need to get in our advertisements and in our specific responses to, you know, if there are two employees sitting next to each other, the point is that they can understand what the other one makes, but does it have to be an exact number, or can it be a range? And the same with, and this is specifically current law in California. What is it likely to look like in Massachusetts?
I think the only change that we could potentially Massachusetts having or federally that impacts Massachusetts would be the requirement of a salary range. It wouldn't be a specific salary because again, there are allowable pay discrepancies. If someone has more experience, if they have higher education, if they have more designations, if they have a certain specialty. I mean, again, you have design professionals that may be very unique, that might have a niche that they garner more money than someone else. Even though, you know, all things considered, they may be otherwise the same. They might have a specialty that is unique to them that warrants another $5,000, you know, or whatever it might be. That's legitimate. So you can have a range, and I think that's the only thing that might come to here in Massachusetts, where when you're posting and advertising a job, you may be required to put out that range, and then you're not going to be allowed to take from it when you hire someone, unless you some sort of criteria. So that right now doesn't exist in Massachusetts. We don't have to put out a range. We can just put a job posting. And we do have to, though, hire people and treat them in an equitable way based on gender. And we can only change their pay based on those factors that I identified.
Yeah. Okay, thank you.
So that might be coming. So it's something to consider doing and toying with now, and you can kind of play with those job advertisements now.
Yeah.
Because it might be something that happens down the pipe. It's tricky. It
Yeah.
really is.
I have a question about remote work. Right now, it just seems like the rules are kind of like all over the place, like of whether you can require people to come in, whether you request them to come in, like, are there things coming that are gonna define it more? Or is it just, do you think it's
I
just
don't
gonna
think
be?
so. I think we're at the point now where, you know, the pandemic has officially been declared, you know, President Biden's come out and said there's no further pandemic, you know, we're not doing any sort of aid, no more relief, everything's kind of, we're in this post-pandemic world. I really think that. I think that we've kind of reached our new normal. I think for design professional, you are unique because you can perform your job. Many of them can perform their job in this hybrid world, right? They can work remotely and then come to the office. So not everybody's like you. You know, I have a lot of clients that are manufacturers or other, you know, free companies and landscapers, and they have to go to work every day. They can't perform their job remotely, but you can. So it makes it a lot harder. And when you're trying to attract talent and keep and retain talent, it makes it a lot harder for you because you all have to compete with each other. And if somebody else is offering, you know, 75% remote and you're requiring everybody to be back in the office 100% of the time, it makes it really difficult. But I think we've kind of reached our new normal. I don't think there's going to be something that further defines what is remote, what is required. I think we may ultimately finally see something among the states because there's been a lot of pressure, and we've, as lawyers, we've been, it's very difficult to advise on the tax implications of people working remotely out of state and what laws apply. And it would be great if there was something either federally or that the states could all agree as to how to treat employees that are remote, but report to, let's say, a Massachusetts location. How do we treat that employee? And there's really no unanimity among the states as far as how to treat remote workers. And hopefully at some point that will become a topic that gets addressed, because I would like to see from a tax standpoint and from which laws apply, what happens. Now we take the position because of case law from before the pandemic, that if you have an employee, they report to a Massachusetts location and their duties are directed from Massachusetts, that the Massachusetts laws apply to them as far as the Wage Act and such. So that's the position we take based on cases here in Massachusetts, basically, even before the pandemic, had remote employees and held those things. So that's the position that we take, but there's still an argument made that, well, does other laws apply to them? And do you have to comply with a different family statute in a different state? So there's a lot that's still unanswered, and we as lawyers don't like that. We don't like that gray area. We'd like it all to be black and white, but and hopefully at some point there will be more answers. But I think this is what we've got right now. I don't see anything kind of coming down the way in 2023 to further help us or define the remote workplace.
I think we as people in HR don't like the ambiguity either. Just saying.
Yeah, you guys, I think, are really design professionals in particular. It's tough because you really are, you can work hybrid, and I'm sure a lot of your professionals want the continued flexibility post-pandemic. Don't want to travel into the city, don't want to take tea anymore, don't want to have to deal with some of the childcare situations that they had to deal with previously. And honestly, some of them are probably can do their job quite well at home. But I think you certainly lose some of that collaboration. And as design professionals, they do need to review each other's work, they do need to collaborate, and they do need to ultimately meet with clients. So you do have to require them to come in sometimes, but what is the balance, and where is that? And how do you strike that balance? I don't know. You guys are walking that line every day.
Well, I think the other problem too is with people who work remotely, they don't have the commute, obviously, and the people who do come into the office do have the commute. And so there's been some actual discussion about should you count? And a lot of times when people go to job sites, you start counting your time from the time you leave the office till you go to the job site. So now do you do it from when the time you leave your home to go to the job site? So that time is covered. And then other people are saying, well, if they're getting paid for that time, shouldn't that commuting time count as my working time? We count it when we charge our clients, and this is just, yeah, chaos.
Oh, interesting. So we do get a lot of questions on travel pay and what's compensable time. And obviously we all know that commuting to the office is not compensable time, but then the question becomes, is commuting to the job site compensable time? And when does compensable time begin? And typically, traditionally, commuting to the job site would not constitute compensable time if that was part of their normal commuting. And then commuting from the job site back to the office would be part of the workday. So that would be, it would be on the clock, so to speak. But most of these people are professionals. So they're not hourly employees. You know, they're getting paid a set salary. So it's a little bit less difficult for you all, but there, you know, we get these questions a lot when they're laborers, you know, and they're not design professionals. They're actual people driving a truck that are going to paint or going to do HVAC work or whatever the case may be, because we represent a lot of companies that, and they're wondering, well, if I get in my work truck and drive it to the job site from my house, is that compensable? So we do get a lot of those questions, but it's interesting how you're starting to get some of those questions because people want to get credit for commuting.
For us, the trickiest line to walk has been around the childcare, the wanting to people who got very used to being home and taking their kids to school, picking them up, and you know, half our employees seem to love coming to work to escape that chaos at home, and then half really, really like it and miss it, and now say, well, I want to be a good mom. I want to get my kids off the bus. Okay. How do we determine? I mean, it's very tricky to manage that when you know that somebody is working from home with very young children in the house at the time. They've opened up their lives to you in a way that you know they're
Right.
working home with small children. And I mean, the proof is in the pudding. Are they getting it done? When are they getting the work done? Is the work as strong as it used to be? It takes a lot of managing. And that is the hard part to talk about. It's like, okay, we've, all these rights that were somehow given to you by COVID that you now, I mean, don't get me started on the dogs. Like the people who adopted dogs and now say, well, I can't come into work because I have a dog now. It's like, what did you do before? I mean, some people managed to figure out what to do with their children and their dogs, but now it's up to us as the HR people to figure out what to do with their children and their dogs. And some people find it very difficult to talk about. I do not. But I think can say to people, a lot of people did have dogs before COVID. They managed to figure out what to do with them. But it's a tricky, I just don't know where it comes into. I think it's more a hourly versus salary, exempt versus non-exempt issue. And you just have to hope that people are getting their work done outside the normal work hours.
I agree. And I think having in your remote work policy, specifically stating that the remote work arrangement can be altered at any time, and to the extent that they're not meeting performance expectations, the remote work can be eliminated, and there can be an expectation that they have to come into the office full time. I think making sure that that's known, and then that's actually adhered to. If they have a performance issue, that it's communicated to them that, you can keep working remotely for the next 3 months, but if we don't see improvement, you're going to have to come back full time because we think your hours are suffering. We think your work is suffering. And we think it's attributable to the fact that you're not in the office.
Yeah.
But it is a hard situation to manage. And I, as a mother of 2 children who are 14 and 11, there's no way I could have worked with young children in the home and got my job done. So I don't know how people do it, because you'd have to ignore your children.
Yeah.
Do your job, because this is a job that is professional services, whether it's lawyering or being an architect. You have to attend and you have to pay attention to what you're doing. And you can't just do mothering and working. It doesn't work that way. Now, you could obviously have a schedule where you get them off the bus, you get them situated, and then you hop back on and you tell the kids, you guys have to be on your own, do your homework and do what you do. But when they're really young, you can't do that.
No, but we've had employees who shifted their schedules and said, we've started trying to do something called core hours, even pre-pandemic, and just said, because people come into the office at 7:30, 8 o'clock in the morning, other people come in and they leave at 4 o'clock, between 4 and 5. And then other people come in at by 10 and leave at 6. You can shift those hours. And as long as they're getting the work done and the shift works, maybe one of them takes the morning shift and somebody else takes the afternoon shift or something. I have people who literally work, I know they work from, 9 to 10:30 at night.
Right.
That's what they do. But
If they
I
have
think
a
that it's
partner
are they
and
getting
they
the work
can work
done?
out a schedule that works for them. But some companies don't want to allow that too. Some companies want people to be on the computer from 9 to 5. So it has to be something that's acceptable to your firm, and those core hours have to be something that works for you.
I think that's been the hardest thing, even with COVID, post-COVID, pre-COVID. When are you what are your hours? When are you working? And making, I don't know why people have such a hard time asking that. I don't understand why. I'm fine with, I'll tell you what hours I work.
Yes.
Yeah, I think
Small
this is,
fee, I'll do it for your company.
yeah, we definitely share that same sentiment, Jessica and Ann, but I think this is where the culture building comes into place to kind of fill in the gap and kind of let people cultivate the culture around asking these questions and being communicative with their colleagues, and being open and honest and transparent. Like you said, Jessica, people have opened us into their homes. We saw them in their PJs, working, in their darkest moments. So how do we can't expect everyone to go back to pre-pandemic life, because that doesn't exist. So kind of building into our policies reasonable expectations around this flexibility. And I like to think of harmony instead of balance, because balance kind of thinks like there's a negative, or there's a losing element there, but harmony creates there's going to be an ebb and a flow. So if there is a time where there's summertime and there's school let out, I don't have any kids, so I don't know. But I was a kid once, and my summer camp let out at 2:30. So, what does that mean for our working parents today, or our working guardians today? And et cetera. So how do we create harmony for our professionals, and reasonable and fair accommodations, and in making sure the accommodations feel even. I know I've heard that from our more junior staff of like, our more senior staff, it feels like they get to do whatever because it feels like they have these reasons. And some may say excuses, some may say, well, they've got, kids, they've got other obligations that, or the seniority, the merit, what all the other big words. So how can we make all staff at all levels feel that that there's opportunities for them to experience this, and really take advantage of the flexibility that work from home offers. And it's not easy, and it just takes honesty and ownership of when we do flub up. But that's when the culture building part comes in. But and what are people's work hours? All of that is on a Google Calendar. You can put where you're working on what day. I just sent out a reminder email. Set your working location, guys. We need to know where you are when. It's all about, it's all a process.
We used to have a paper calendar that literally like people filled in pre-pandemic, obviously. And so we went to pandemic, I created one online, and now it's the same. It's like the struggle with timesheets. Getting them to actually do it is I totally. And it's, I absolutely agree with you. I feel like it's the people who are most senior who don't walk the walk, and then makes it really hard to enforce it at the other levels. And
yeah, this kind of like building this into our new culture, it has to be modeled behavior. And, we're knocking against the walls, you want to shake somebody, but also it's like the only way that we can see positive change and, substantive change is for our leaders, our executives to, like you say, walk the walk, and pre-pandemic, we didn't want them to work crazy 12, 16-hour days. They were modeling poor behavior, workplace behavior. We want them to model good behavior now in the same way. So this is all part of the culture building aspect. It's a lot of work, but we can do it. Thank you guys. I really appreciate it. I got to hop off, but thank you so much. This is really informative.
We've run over our time, so thank you so much, Jennifer.
Thank you, Jennifer.
Thank you, Jennifer.
You're welcome. My pleasure. Hopefully it was informative. I enjoyed being with you all today.
it's great to see you. Thanks again.
Take care.
Thank you so
Thanks,
much.
everyone.
Thank you.